If you committed a crime in Canada, the only way to overcome inadmissibility for immigration purposes is to apply for a record suspension with the Parole Board of Canada. A record suspension is essentially a pardon. In order to be eligible, you must have completed all of your sentences, and I do mean all. All fines, surcharges, costs, restitution, and compensation orders must be paid in full. All sentences of imprisonment and conditional sentences, including parole and statutory release, must be completed. As well, any term of probation must have concluded. You must also have completed the appropriate waiting period, which is based on when you committed the first offense and whether the offense was prosecuted summarily or as an indictable offense. For offenses committed on or after March 13th, 2013, the waiting period is 10 years for an offense prosecuted by indictment and 5 years for an offense punishable on summary conviction. These waiting periods are notably longer than they once were. For offenses committed before June 29th, 2010, the waiting period is only 5 years for offenses prosecuted by indictment and 3 years for offenses punishable on summary conviction. For those offenses committed between June 29th, 2010 and March 12th, 2012, the waiting period depends on more technicalities. For example, whether it is a serious personal injury offense or an offense referred to in Schedule 1, but the range is in between 3 to 10 years.